The 2026 Immigration Climate, Understanding the Shift. As we move through February 2026, a significant and palpable shift has taken hold of the American immigration landscape. For more than 26 million naturalized citizens, a status once considered the finish line of a long and arduous journey is now facing unprecedented levels of public and internal scrutiny. Headlines are dominated by terms like immigration overhaul, crackdown, and deportation, leading many who have already taken the oath of allegiance to feel a new sense of vulnerability. However, to navigate this era effectively, one must separate the political rhetoric from the bedrock of constitutional law. The current environment under the Trump administration is characterized by heightened enforcement visibility, where workplace raids and large-scale removal operations are frequently highlighted in the media. While these actions primarily target individuals who are undocumented or have final removal orders, the intensity of the atmosphere often collapses different legal categories into one emotional narrative, causing naturalized citizens to worry if their own status is as permanent as they believed. It is essential to understand that while the tone of enforcement has become harsher, the fundamental legal relationship between a citizen and the United States remains distinct from any other immigration category. In this comprehensive 15-part breakdown, we will examine the new internal policies, the technological advancements in surveillance, and the enduring constitutional protections that define what it means to be a naturalized American in 2026. Clarity is your strongest defense against the spread of misinformation in this high-stakes environment. Political messaging versus legal authority. To truly understand the 2026 landscape, we must distinguish between political messaging and actual legal authority. Since the beginning of the year, the Trump administration has signaled a pivot toward a more aggressive interior enforcement strategy, often using broad language such as immigration overhaul and deportation push. While these phrases dominate the 24-hour news cycle, they often collapse distinct legal categories into one emotional narrative, leading naturalized citizens to feel as vulnerable as those who are undocumented. However, executive orders and shifts in political rhetoric cannot simply rewrite the Constitution. The executive branch manages the machinery of enforcement, but it remains bound by the 14th Amendment and existing federal statutes. Legal experts emphasize that while an administration can change how agencies like USCIS prioritize their workloads, they cannot pass a simple administrative memo that strips a lawfully naturalized citizen of their status. Therefore, even if the tone of the government feels harsher or more visible in 2026, the structural legal protections surrounding your citizenship remain anchored in decades of Supreme Court precedent. This means that the scaffolding of your legal rights does not move with every election cycle. Understanding that visibility is not law is the first step in replacing instinctive fear with factual clarity. The 14th Amendment, a permanent shield. The ultimate anchor of your status is the 14th Amendment to the U.S. Constitution, which guarantees that all persons naturalized in the United States are citizens of the nation. This is not a conditional status that expires or requires periodic renewal, unlike a green card or a visa. In 2026, it is vital to remember that once the oath of allegiance is taken, you stand on the same constitutional footing as a native-born citizen. Your citizenship is a constitutional status, not an administrative one, and it provides a level of protection that cannot be swept away by a policy shift or a new deportation wave. Many naturalized citizens subconsciously carry the anxiety of their years as permanent residents into their lives as citizens. They may remember the provisional nature of their residency, where certain actions could trigger removal proceedings. However, the law is clear. Citizenship is final. It is not a privilege that can be casually revoked because of political disagreements or changes in executive priorities. Unless there was a fundamental legal defect in how the citizenship was originally obtained, the 14th Amendment remains an unbreakable shield that secures your right to remain in the United States indefinitely. Understanding Denaturalization, Section 340. While citizenship is permanent, there is a narrow legal path for its revocation known as denaturalization, governed by Section 340 of the Immigration and Nationality Act. It is important to define this term precisely, as the word itself often causes unnecessary panic. Denaturalization is not a tool used against law-abiding citizens who make minor mistakes. It is a formal legal process specifically designed to address cases where citizenship was illegally procured or obtained through the willful concealment of a material fact. In 2026, the government must still prove that a person deliberately lied about something significant during their naturalization process, such as concealing a serious criminal history, using a false identity, or hiding involvement in extremist organizations or human rights abuses. The legal standard remains focused on willful deception regarding material information that would have resulted in an original denial. Honest mistakes, memory gaps, or clerical errors made decades ago were never intended to meet this high bar. Therefore, if your naturalization was obtained lawfully and honestly, the machinery of denaturalization is not a threat to your status, despite how often the term appears in recent headlines. The judicial process and burden of proof. One of the most powerful protections for naturalized citizens is that denaturalization cannot happen through an administrative sweep or a backroom decision. It requires a formal civil lawsuit in federal court. Unlike deportation proceedings, which occur in administrative immigration courts, a denaturalization case places you as a defendant in a federal district court with full due process rights. This means you have the right to legal representation, the right to discovery, to see the government's evidence, and the right to present your own defense before a judge. Furthermore, the burden of proof rests entirely on the government, and the standard is exceptionally high: clear, unequivocal, and convincing evidence. This is a significantly steeper requirement than the standard used in most civil cases, reflecting the gravity of stripping a person of their American status. Historically, these cases are time-consuming, expensive, and rare, not mass actions. In 2026, even if an administration directs agencies to refer more cases for review, each case must still pass through this individual judicial gauntlet. This structural barrier ensures that citizenship revocation remains a measured legal outcome rather than a political lever. Why 2026 feels different? Enforcement targets. If the law remains the same, why is the atmosphere in 2026 so unsettling? The answer lies in enforcement intensity and shifting internal priorities. Reports indicate that USCIS field offices are now being encouraged to search for old naturalization cases that might qualify for review, with some internal targets suggesting between 100 and 200 potential referrals per month. This represents a fundamental shift from a reactive posture, waiting for major fraud to be discovered, to a proactive search through historical files. When enforcement moves from exceptional to systematic, the scale of the system changes. In previous years, the U.S. averaged very few denaturalization cases annually, but the new 2026 approach could see those numbers rise significantly. While the goal is officially to correct past fraud and protect the system's integrity, the pressure to meet referral targets has raised concerns that minor technical discrepancies from decades ago might be re-examined through a more aggressive lens. This transition from once American, always American to a culture of re-examination is what has millions of citizens paying close attention to their old paperwork. The digital net and data sharing modern technology is a primary driver of the 2026 enforcement push. For the first time, federal agencies are implementing complete real-time data sharing between the IRS, FinCEN, the Social Security Administration, and USCIS. This means that the financial information you report on your taxes is automatically cross-referenced against your immigration history. If you answer a question about a foreign bank account on your tax return, the system can instantly check if that account was disclosed during your green card or citizenship applications. Furthermore, the digitization of old paper records allows automated systems to scan millions of documents for inconsistencies that were once nearly impossible to find. Biometric data can now be compared against international databases to identify if an individual used a different name or concealed a prior visa denial years ago. For the 26 million naturalized citizens in the U.S., their immigration history is no longer buried in a warehouse. It is a searchable digital file. While this technology is designed to catch serious fraud, its precision means that even small, unintentional errors can now trigger an automatic flag for human review. High scrutiny categories and materiality. The government has clarified that its 2026 review efforts are not a random sweep of every citizen, but a focused effort on specific high-risk categories. The primary targets are individuals who allegedly used material misrepresentation to secure their status. This includes four main groups: those with hidden criminal histories, individuals who obtained residency through proven marriage fraud, people with ties to extremist groups, and those who used completely false identities to bypass the immigration system. The concept of materiality is key. The government must prove the omitted information was so significant that it would have legally changed the outcome of the application. For example, if a green card was obtained through a sham marriage and then served as the basis for naturalization, the entire foundation of that person's citizenship is considered legally defective. However, the fear in 2026 is that the definition of what is material could slowly expand to include minor travel discrepancies or employment dates as offices work to meet their referral quotas. Understanding these categories allows honest citizens to recognize that their legitimate path to citizenship, while perhaps imperfect in detail, does not fit the profile the government is searching for. The IRS Banking Rule Connection 2026 Update. A critical part of the 2026 update involves new IRS and banking rules that specifically target seniors over 60 and immigrant filers. Starting with the 2026 tax year, the IRS is lowering the mandatory reporting thresholds for foreign financial assets. For this group, the requirement to file Form 8938 now drops to just $25,000 at the end of the year or $40,000 at any point during the year, significantly lower than the standard limits. Additionally, new mandatory questions about foreign bank accounts, pensions, and Social Security benefits will appear directly on the standard Form 1040. These financial rules are directly linked to immigration enforcement through the good moral character requirement. Because of real-time data sharing, a failure to report a small savings account in your home country on a tax return can now be instantly seen by USCIS. The government believes these groups often have unintentional non-compliance due to ties abroad, and they are using these new unavoidable questions to force disclosure. For naturalized citizens, keeping a clean financial record is no longer just about avoiding a tax audit. It is now a fundamental part of maintaining a secure immigration profile in the new digital net. Impact on the Indian American community. The 2026 crackdown and financial updates are being felt with particular intensity within the Indian American community. As the second largest group of naturalized citizens, many Indian-born Americans spent decades navigating a marathon of temporary H-1B visas and green card backlogs before finally reaching citizenship. Because this community often maintains deep ties to India, including family properties, bank accounts for aging parents, or foreign retirement funds, they are highly susceptible to the new, lower financial reporting thresholds. Many in this community now worry that technical inconsistencies from their long years in provisional status could be re-examined. For instance, a miscalculated travel date from 15 years ago or a small, inactive bank account that was not reported can now trigger a flag in the automated system. This chilling effect has led some to hesitate about international travel or interacting with government agencies. However, legal experts remind this community that their hard-earned status is still protected by the Constitution. Precision in current reporting and organization of past records is the most effective way to address these new 2026 scrutiny standards. Debunking common myths. Misinformation often spreads faster than law during a crackdown, and it is vital to debunk three common myths circulating in 2026. First is the myth that crimes committed after you become a citizen can lead to automatic revocation of status. Generally, this is false. A citizen who commits a crime faces the domestic criminal justice system but does not lose their citizenship unless the crime proves they lied during their original naturalization. Second is the claim that the government can revoke citizenship for speaking a native language or criticizing the president. Political speech and cultural expression remain protected by the First Amendment for all citizens. The third myth is that naturalized citizens need to pay for special protection services or register with organizations to secure their status. Your citizenship is already legally secure under the Constitution. No private service or additional filing can increase that protection. Fear-based businesses often emerge in uncertain times, but they cannot override federal law. Understanding these facts helps strip away the emotional residue of the immigration process and allows you to live in the stability you have rightfully earned. Practical preparation. The record audit. In the 2026 environment, being organized is your strongest defense. Experts recommend that every naturalized citizen conduct a personal audit of their immigration records. This includes keeping a secure file with your naturalization certificate, copies of your N-400 application, and all supporting documents such as old passports and tax returns. If you do not have copies of your old filings, you can request your entire A file through a Freedom of Information Act (FOIA) request to see exactly what the government has in its records. Having immediate access to this proof eliminates stress if you are ever asked a question during a passport renewal or a family sponsorship petition. It also allows you to identify any technical inconsistencies, such as a forgotten trip or an old address, before they become an issue. Organization transforms a potential moment of panic into a routine verification. In a world of automated data sharing, being able to prove you did things right is just as important as actually doing them right. Protecting the family unit. A common question in 2026 is whether it is safe for family members to apply for citizenship given the current intensity. Despite the detailed interviews and longer processing times, the answer from legal experts remains a resounding yes. Lawful permanent residents are actually more vulnerable than citizens. They can be placed in removal proceedings for certain crimes or extended absences, and they must renew their status every 10 years. Citizenship provides a finality and a level of constitutional protection that a green card simply cannot offer. If a family member is eligible, naturalizing is the best long-term security move for the entire household. Stability at the top of the ladder, citizenship secures the status of the entire family unit in an enforcement-heavy climate. While they should be meticulously honest and well prepared for the interview, crossing the finish line to citizenship remains the ultimate goal for any immigrant family seeking peace and belonging. Navigating legal assistance and avoiding scams. If you have a complex immigration history or receive a notice from the government, seeking professional help is essential, but you must be careful where you turn. In 2026, many predatory services and notarios may exploit fear by promising guaranteed outcomes or claiming they have inside connections. You should only rely on licensed immigration attorneys or reputable legal organizations. A real attorney will evaluate your facts, explain risks clearly, and never promise impossible results. They can help you navigate the 2026 IRS disclosures, handle materiality questions, or represent you if a past filing is ever questioned. Be cautious of anyone demanding large cash payments without a written agreement or invented emergency filings that do not exist. Legal guidance should reduce your anxiety through accurate information, not exploit it through misinformation. Staying informed through official sources like USCIS or the Department of Justice is your best way to verify the legitimacy of any news or notices you receive. Conclusion: security through awareness. As we conclude this deep dive into the 2026 updates, the core message is that your citizenship is stable, but your awareness is required. We are living in a turning point for American immigration history, where the honor system of the past is being replaced by a sophisticated digital and proactive enforcement framework. This shift is real and visible, but it does not erase the constitutional guarantees that protect you. Your strategy for the future should be simple. Stay organized, be honest in your financial reporting, keep copies of your historical records, and do not let political noise take away your peace of mind. You earned your place in the American story through years of work, patience, and the oath of allegiance. Citizenship is one of the strongest legal statuses in the world, and it remains the ultimate protection against a changing policy climate. By understanding the rules and your rights, you can move forward with the confidence and security you deserve as a full member of the United States. Knowledge is your greatest protection.